You're listening to the Quarterly Pensions Legal Update, brought to you by the Pensions team at Gowling WLG. Every 3 months, we bring you an overview of the key legislative, policy and regulatory developments, along with a roundup of key pensions cases and Ombudsman's determinations. You can watch this update as an on-demand webinar or just listen to the audio as a podcast. A full text version of this update is also available to download as a PDF. The text version also includes links to more detailed insights produced by the pensions team at Gowling WLG, along with relevant external publications, the full text of judgments and determinations. You can find out more about the pensions team and sign up for regular updates at www.gowlingwlg.com/pensions-UK. Coming up this quarter, new defined benefit scheme investment guidance from the pensions regulator, a proposal from the DWP on a new deferred debt arrangement, changes to pensions taxation under the Spring Budget 2017 and Finance Act 2017, the DWP's long-awaited Green Paper on the future of DB pension schemes, a decision on the general levy on very large schemes being reduced, and the latest from the courts and the Pensions Ombudsman, including a High Court case on pension increases and revaluation, and 2 Pension Ombudsman cases that focus on ill health. But first, plans put forward by the Department for Work and Pensions on capping early exit charges and banning member-borne commission payments. The DWP has issued draft regulations that will limit or ban early exit charges in occupational pension schemes and ban member-borne commission payments in occupational pension schemes. On early exit charges, the draft regulations introduce a cap and ban in respect of early exit charges in occupational pension schemes. There'll be a cap of 1% on early exit charges for existing members and a total ban on early exit charges for new members. The Financial Conduct Authority has already capped or banned charges from the 31st of March 2017 for personal workplace pensions. Certain adjustments, such as market value reductions, are not subject to the cap and ban, so care is required when implementing any changes. The draft regulations also seek to prohibit member-borne commission charges for occupational pension schemes that are used for automatic enrolment and are in place on the 6th of April 2016. Member-borne commission charges are charges used to recover the cost of commission payments to advisors. Member-borne commission charges are already banned under new arrangements that were entered into after the 6th of April 2016. Trustees and managers of affected schemes have to notify service providers that the scheme is used for automatic enrolment. This was the case when the ban was introduced for new arrangements last year. The regulations are likely to be effective from October 2017, assuming that they're brought into force as they're currently drafted. Schemes will need to be mindful of the changes, the requirements to notify service providers, and various nuances in the regulations. For example, market value reductions not being subject to the cap and ban on early exit charges. The pensions regulator publishes new investment guidance for defined benefit scheme trustees and advisors. The pensions regulator has issued new guidance on investments for trustees and advisors running schemes that provide defined benefits. The defined benefit investment guidance sits alongside the pension regulator's Code of Practice No. 3, Funding Defined Benefits. The Defined Benefits Funding Code sets out the standards that are expected to be reached in complying with the law. The Defined Benefit Investment Guidance provides practical information, examples, and factors to consider on how trustees and advisors might meet standards in practice. The Defined Benefit Investment Guidance covers 6 areas: governance, investing to fund defined benefits, matching assets, growth assets, implementation, and monitoring. Some of the more useful aspects of the Defined Benefit Investment Guidance are checklists of what the pensions regulator believes is best practice in respect of putting together a statement of investment principles. how trustees should work with investment advisors, collaborative working with the scheme's employers, appointing a fiduciary manager, and developing a scheme's investment journey plan. There are also useful examples of approaches trustees could take and factors to consider when investing scheme assets. The Defined Benefit Investment Guidance sets out the regulator's view of best practice in respect of investment for defined benefit schemes. Whilst it doesn't say anything revolutionary, it does provide a useful overview of the relevant considerations for trustees and their advisors. In addition, the checklists could provide a useful risk management tool for trustees, going through various changes such as appointing new investment managers. New deferred debt arrangement proposed by the Department for Work and Pensions for defined benefit multi-employer schemes. The Department for Work and Pensions has proposed a new deferred debt arrangement to enable employers in multi-employer pension schemes and not just non-associated multi-employer schemes to defer the requirements to pay an employer debt if they cease to employ an active member. The points we make in this section are based on the proposed deferred debt arrangement structure, which is subject to consultation. The deferred debt arrangement structure would enable employers whose only change of circumstance is ceasing to employ an active member to retain an ongoing commitment to the scheme. The deferred debt arrangement would be in addition to existing options, such as entering into scheme apportionment arrangements or withdrawal arrangements, and it would require the trustees of a scheme to consent and the scheme funding test to be satisfied. A deferred debt arrangement would not be available if the scheme was in a PPF assessment period, or it was likely to start such a period within the next year, or if the scheme was in the process of being wound up. The deferred debt arrangement would end if certain events happened, such as the deferred employer choosing to trigger the Section 75 employer debt, the scheme starting to wind up, an insolvency event occurring in relation to the deferred employer, a freezing event occurring in relation to the scheme, or the deferred employer restructuring. Trustees would still have to monitor funding and assess the deferred employer's covenant. Trustees would also be able to end the deferred debt arrangement if they felt that the deferred employer was not complying with its obligations, or that ending the deferred debt arrangement would be in the interests of the scheme. The proposed deferred debt arrangement may help some employers who are otherwise stuck and unable to pay an exit debt on the more expensive buyout basis, but who are able to continue paying their liabilities on the less expensive technical provisions basis. However, it's important to note that this proposal simply offers a deferral of the employer's debt. The deferred debt arrangement would not address the concerns of some unincorporated employers who are unable to withdraw from a scheme and discharge their liability completely. The general election causes delay in the implementation of the spring budget. The Chancellor of the Exchequer, Philip Hammond, delivered his spring budget to Parliament on the 8th of March 2017. Workplace pensions did not feature as one of the main areas for the Treasury's focus. The budget did, however, confirm a previously announced reduction in the money purchase annual allowance. It also unveiled a charge on certain transfers to a qualifying recognised overseas pension scheme, or QROPS. All of this was reflected in the first draft of the Finance Bill 2017. HM Treasury's legislative plans were interrupted by the announcement of the general election. A revised Finance Bill 2017 was pushed through before Parliament prorogued at the beginning of May. Certain budget pledges were not included in the revised draft, but may be reintroduced in the next parliamentary session. The Overseas Transfer Charge. A new 25% overseas transfer charge applies to transfers to QROPS requested on and from the 9th of March 2017. The overseas transfer charge will apply unless an exemption applies. For example, if the member is resident in the same country in which the receiving QROPS is established, or the member is a resident in a country within the European Economic Area, and the QROPS is also established in the European Economic Area. The overseas transfer charge must be deducted by the pension scheme administrator or manager prior to making the transfer and is based on the transferred value. The transferred value is typically the total amount and value of assets transferred. Refunds of the overseas transfer charge are also possible, for example where the individual makes a taxable transfer and within 5 tax years one of the exemptions applies. Members qualifying for an exemption have ongoing duties to provide information to the scheme manager or administrator following certain changes in their circumstances. For example, should one of the conditions for exemption subsequently cease, in which case the overseas transfer charge may become due. If the individual ceases to qualify for an exemption, the QROPS receiving a transfer which is not subject to the OTC is also potentially subject to UK tax provisions. Any payments out of the QROPS in the 5 years following the transfer could attract a UK tax liability. Liability of scheme managers and/or administrators is joint and several with the member, and there are new reporting obligations for the overseas transfer charge. HMRC required QROPS to undertake to operate the overseas transfer regime by the 13th of April 2017. Any QROPS that failed to provide this undertaking ceased to be a QROPS on that date. The money purchase annual allowance and pensions advice payments. In his budget statement, the Chancellor also confirmed a reduction of the money purchase annual allowance from £10,000 to £4,000 with effect from the 6th of April 2017 and an increase in the maximum tax-free amount an employer can pay towards pensions advice for employees of £500 each year, up from £150. This is the employer-arranged pensions advice exemption. The Finance Act 2017 did not contain the original draft clauses implementing these provisions. It's understood that the government plans to reintroduce these if they win the election. At this time, there's no confirmation whether this would take effect retrospectively to the 6th of April 2017 or from the effective date of the new legislation. This uncertainty is unhelpful for employers, trustees and administrators. Schemes may have already informed members that since the 6th of April 2017, the limit of the money purchase annual allowance is £4,000. In addition, the pensions advice allowance payment came into effect in April 2017. The pensions advice allowance payment allows individuals to take £500 from their DC pension pots to redeem against the cost of financial advice on 3 separate occasions before the age of 55. Whilst the pensions advice allowance payment is an authorised payment, there are concerns that currently such payments may be subject to income tax. The government has said that the pensions advice allowance payment would not be taxed on withdrawal regardless of the individual's income. It would not affect a member's ability to take up to 25% tax-free as a lump sum when benefits are ultimately taken, and that it was intended to be made tax-free. Whilst the policy intention is clear, there isn't anything obvious in legislation that actually makes the pensions advice allowance payment income tax-free. This ambiguity has been raised with HMRC. So what are the next steps and actions for trustees? For overseas transfer charges, when transferring benefits, UK scheme administrators will need to check the status of the receiving scheme. If the receiving scheme is a QROPS, the overseas transfer charge may apply. If the receiving scheme is not a QROPS, but the receiving scheme is situated overseas, the transfer could attract other charges as it's likely to be an unauthorised payment. This could incur an unauthorised payment charge or scheme sanction charge. Checks and a level of due diligence is therefore required before a scheme makes such overseas transfers, and HMRC has provided guidance on this. For money purchase annual allowance, the existing limits continue to apply, so £10,000 for money purchase annual allowance and £150 for the employer-paid pensions advice. The consensus amongst financial advisors appears to be that it's better for people to work on the basis that the money purchase annual allowance is actually £4,000. This is on the grounds that if no change is made for this tax year by the new government, there will still be time for individuals to make additional contributions later in the tax year. To do so otherwise at this stage would risk incurring retrospective tax charges. And finally, on the pensions advice allowance payment, schemes should watch and wait if they're considering making pensions advice allowance payments, pending confirmation of the tax-free status. If they decide to go ahead with any such payments, the ambiguous tax status should be made clear in any member communications. The Department for Work and Pensions issues a green paper on the future of defined benefit pensions. The DWP has published its pensions green paper, Security and Sustainability in Defined Benefit Pension Schemes. After last year's high-profile pension cases and the Work and Pensions Select Committee's inquiry and report on the future of DB pension schemes, the DWP is now seeking views on the challenges facing DB pension schemes and how to restore confidence in the defined benefit system. The Green Paper focuses on 4 key areas: funding and investment, employer contributions and affordability, member protection, and the consolidation of schemes. Responses to the Green Paper had to be submitted by the 14th of May 2017, and the DWP is currently considering the responses made. Trustees and sponsors of defined benefit pension schemes will be very interested in the issues raised. The Green Paper is wide-ranging, but it is difficult to comment accurately at this stage on the extent to which statutory changes will actually be introduced. The pensions team have produced 2 detailed alerts on the Green Paper, the first focused on trustee issues and the second on employer concerns. These alerts are available at gowlingwlg.com/pensions-UK. In terms of timing, we don't expect it to see any final legislation in place this year. It usually takes between 12 and 18 months for policies to develop from the Green Paper stage to final legislation. However, the focus on these issues that is being raised in the general election also ensures that defined benefit pensions will continue to be in the spotlight for the foreseeable future. The general levy on very large schemes is to be reduced. In its response to the consultation on the draft Occupational and Personal Pension Schemes General Levy Amendment Regulations 2017, the DWP has confirmed that the rate of the general levy on pension schemes with more than 500,000 members will be reduced from 2017-2018 onwards. As a reminder, the general levy on occupational and personal pension schemes is collected by the pensions regulator and provides the Department for Work and Pensions with the core funding for the pensions regulator, the pensions advice service, and the pensions ombudsman. In its original consultation, the DWP put forward 3 options: to leave the current levy rate unchanged for all schemes, to reduce it for all schemes, or to reduce the levy rate for very large schemes whilst freezing the rate for smaller schemes. At that time, the DWP also stated that its preference was to implement the third option by creating a new levy rate for pension schemes with 500,000 or more members, which would be set at a level 25% lower than the current levy rate, which applies to schemes with 10,000 or more members. Workplace pension reform has resulted in a small number of schemes with very large memberships. The Department for Work and Pensions believes that under the current regime, such schemes pay a disproportionately high proportion of the general levy. The proposed change will reduce the amount to be paid by these very large schemes whilst not placing additional burdens on smaller schemes. The consultation response confirms that this is the approach being adopted. The levy rate for schemes with fewer than 500,000 members remains unchanged. The Occupational and Personal Pension Schemes General Levy Amendment Regulations 2017 came into effect on the 1st of April 2017 to give effect to the new rate. And finally, we'll focus on rounding up pensions cases and determinations from the Pensions Ombudsman. First, we'll cover the latest from the High Court on pension increases and revaluation and the vexed issue of RPI-CPI. In the case of Thalers UK Limited and Thalers Pension Trustees Limited and others 2017, the High Court has provided the most up-to-date guidance on how to interpret and apply rules dealing with revaluation and increases to pension benefits. The case also summarises some of the key features of RPI and CPI and how they are compiled, and this is relevant in deciding between the indices that aim to protect the value of pension benefits against the effect of inflation. The key points from the judgment are to consider the wording in your rule carefully. Small changes in language could make a significant difference to the analysis. To apply the wording on the page, views on suitability, purpose, and merits of one index compared to another are unlikely to be relevant for interpreting a rule, except where those concepts are specifically incorporated into the rule. The case covered an exposition on the compilation of RPI and CPI. There's some detail of the way consumer prices indices are compiled and operate, and what has changed in respect of the RPI and CPI indices over the years. This exposition may assist others in the interpretation of similar rules and save them some research. Ultimately, RPI was the index to be applied. In the particular circumstances of this case, the judge was supportive of a continued role for RPI, stating that exceptional circumstances would be needed for the trustees to consider CPI given the alteration found to have been made to RPI. He's quoted as saying, "In a competition between CPI and RPI has materially changed, I find it hard to see how CPI can win the competition." Mr. Justice Warren avoided being drawn into arguments as to the respective merits of the indices in his interpretive exercise. He did, however, state that RPI and CPI both achieved the purpose of protecting members from the effect of price inflation. He also recognised that RPI is still widely used. Where there is a power or obligation to review the index, that will need to be done within a reasonable period of time, or the ability to make any switch may be lost. Mr. Justice Warren provided a useful summary of the characteristics and compilation of RPI and CPI, which may assist in the interpretation of similar rules. This is the first of two Pensions Ombudsman determinations in which the Pensions Ombudsman has looked at ill health pensions and trustee decision-making. This is determination of Mrs. B, PO 9253. Mrs. B was refused an ill health pension on the grounds that she did not meet either of the definitions set out in the scheme rules. These were a scheme definition of incapacity and the HMRC ill health condition. In either case, the decision to allow the ill health retirement was conditional upon the scheme trustees and the employer receiving evidence from a registered medical practitioner that the member satisfied the medical criteria set out in at least one of the respective definitions. The employer based its decision to refuse the application for an ill health pension on the basis of medical evidence it obtained from its appointed occupational health advisor. This stated that Mrs. B's health could improve with unspecified medical treatment. On the basis of this evidence, Mrs. B's employer concluded that Mrs. B did not qualify for an ill health pension under the scheme. The medical evidence obtained by Mrs. B's employer conflicted with the medical evidence Mrs. B had submitted herself. The Pensions Ombudsman found that the medical evidence obtained by the employer was flawed for a number of reasons, including that it did not specify the treatments that would supposedly help Mrs. B's health to improve, or the period of time over which her health was expected to improve. The Pensions Ombudsman went on to find that Mrs. B's employer should not just have followed its own medical evidence, but should have evaluated it in the light of medical evidence Mrs. B submitted. The decision was referred back to Mrs. B's employer with an instruction to obtain new medical evidence and to pay £500 for the significant distress and inconvenience that had been caused to Mrs. B. This determination provides a useful reminder of how employers and trustees should approach medical evidence in respect of ill health cases. Decision makers should not simply focus and follow on medical advice that they have commissioned themselves. Instead, they should factor that medical advice into a broader context and question it where necessary. Such an approach helps decision makers to consider all the relevant factors rather than simply relying on one set of evidence. The second determination on ill health is Ms R PO 9995. In Ms R, the Pensions Ombudsman has confirmed that information on the degeneration of the original health complaint or evidence of new medical issues does not need to be taken into account when decision makers are reviewing previous decisions in respect of awarding ill health early retirement benefits. The NHS pension scheme operates 2 tiers of ill health early retirement benefits, with Tier 2 offering more generous benefits than Tier 1. Ms R is a member of the NHS pension scheme and suffered ill health in 2009. This led to her dismissal from her job with the NHS in 2010. Initially, the NHS Business Services Authority declined to award Ms R any ill health early retirement benefits at all. Following an IDRP process, the authority reversed its decision and decided to award Ms R the lower of the 2 tiers of ill health early retirement benefits. Ms R brought her complaint to the Pensions Ombudsman, arguing that she was entitled to the higher of the 2 tiers of ill health early retirement benefits. Part of her argument was based on the degeneration of her health condition and the development of new conditions. The Pensions Ombudsman agreed that the authority was correct in reversing its original decision, but that it was also correct in deciding to award Ms R the lower of the 2 tiers of ill health early retirement benefits. The authority was not required to consider evidence of new medical conditions or deterioration of the original medical condition. When reviewing a decision, for example, under an IDRP process, decision makers are not required to explore medical evidence in respect of new conditions or deterioration of the original condition that has occurred or became available after the initial decision was made. Decision makers can, however, choose whether or not to take into account relevant medical evidence that subsequently becomes available and that relates to the original assessment of the original condition when considering an appeal. The decision is therefore also useful in confirming the broad powers that decision makers have when considering the relevance of any such evidence. Thanks for listening to this quarter's Pensions Legal Update. Just a reminder that you can find out more about the pensions team and sign up for regular updates at www.gowlingwlg.com/pensions-UK. I hope you can join us for another Gowling WLG Pensions webinar or podcast soon.